Okay, welcome back everybody for the Vocational Science of Freedom Ins and Outs of Court class. This will be part 2, and we left off going over the Common Law Study Guide from 1215.org. We'll get into the government manipulation of language. So the government tricks. This is perhaps the most important page on this website. The first trick of government is the redefinition of certain critical words in each statute or act, which is what I said before. They, the government, want you to assume the ordinary meaning of the word so as to trick you into reading and interpreting the statute in their favor. Here's a summary of the trick words. Two key words that are redefined in almost every statute are the words person and individual. There are at least two person in law. A natural person is a legal entity of a human being. An artificial person is a legal entity that is not a human being. You have this aspect, and there's more of a definition of natural person. Like I said, the best definition for natural person is pretty much someone who has a capacity for rights and duties. So it's not exactly what you would consider also to be, say, one of the people. If you refer to one of the people has natural law rights and can also exercise them if they wish to. The natural person is just someone who has the capacity for it, meaning they might not exercise it, right? Or they might not have them, the rights meaning, less under certain circumstances. So here are the exact definitions from Barron's Canadian Law Dictionary, 4th edition. Natural person. A natural person is a human being that has the capacity for rights and duties, which is what I said. Artificial person. A legal entity, not a human being, recognized as a person in law to whom certain legal rights and duties may attach, as in like a body corporate. You will observe that the natural person has the capacity for rights and duties, but not necessarily the obligation. The artificial person has rights and duties that may be attached, assigned by laws. Second trick of the government is to use the Interpretation Act to define words that apply to all statutes, unless redefined within a particular statute. That's where you get into, like when you read U.S. Code, say you go into 1 USC, you'll have the definition section in the beginning of the first code. What you'll see then is, particularly with the word person in USC, which, you know what, to make a point, I'll bring this up right now, because 1 USC is so important regarding the definition of the word person that I think we should just take a look at it real quick. And I'll drop it into chat as well. So this is 1 USC subsection 8 of person. And I'll copy it and put it in chat. What is a person under the United States Code? It is person, human being, child, and individual, as including born alive infant. So when you see the word include or including or includes, what it means is this and nothing else. It does not mean and also. So if I created a statute that said trees include oaks and elms, a birch tree would not, therefore, be defined as a tree. Okay? It's important to understand that as far as statutory construction is dealing with. So, person, human being, child, individual, as including born alive infant. Infant, that's the point. In determining the meaning of any act of Congress or of any ruling, regulation, or interpretation of the various administrative bureaus and agencies of the United States, the words person, human being, child, and individual shall include every infant member of the species Homo sapiens who is born alive at any stage of development. This is in 1 USC, so it's right in the beginning of the entire US Code. But the point is that this definition applies to all of the rest of the US Code, unless it's specifically defined differently in a later code. So that's what Bill's getting at when he's talking about statutory construction here, okay? So just to give you a clear example of what they're doing. Without this knowledge, you could assume the ordinary meaning for the words you are reading, not realizing that they may have been defined by the Interpretation Act. Unless these words have been redefined in another statute, the underlying definitions for the two most important words still apply, either from the Interpretation Act or the Canadian Law Dictionary. Basically, they are defined as follows. From the Canadian Law Dictionary, we find that individual means a natural person. So what do they just do? They just use a word to define another word, right? Because we go back up here to artificial person. Actually, I guess they don't use individual in here. But anyway, point is that they'll do this. They'll use one word to define another word. It's circular reasoning. From the Income Tax Act, we find the redefinition. Individual means artificial person. So what he's getting at here is that sometimes an individual will mean a natural person, sometimes it'll mean an artificial person. But the point is that you got to watch that. You have to watch what's going on. You have to realize that they'll sometimes redefine a word with another word. From the Canadian Law Dictionary, we find that person means an individual, natural person, or incorporated group, artificial person. From the Interpretation Act, we find the redefinition, person means a corporation. From the Income Tax Act, we find the redefinition again, person means an artificial person, amongst other things. So you see how they bounce around, so just be aware of that. And always go check and see that whatever the definitions are, that you're clearly aware. And I can tell you right now, just by reading the definition of person in 1 USC, subsection 8, statutes, acts, ordinances, and codes do not apply to we the people. Never have, never will. The third trick of government is to use the word includes in definitions instead of using the word means. They do this in some critical definitions that they want to misinterpret. If they used means instead of includes, then their deception would be expressed by using includes. They rely upon the reader to assume that includes expands the definition, which is, like I said, includes does not mean and also. It means this and nothing else. So whereas in reality, it restricts that definition in some manner, that means restricts the definition. Here's a means definition of the word person from the Bank Act. Person means a natural person, an entity, or a personal representative. Here is an includes definition of the word person. Person, or any word or expression descriptive of a person, includes a corporation. To expose their deception, substitute the word means and you have person, or any word or expression descriptive of a person means a corporation. Both means and includes are restrictive in scope because they only encompass part of the whole. Typically, they are used in the following form. Person means A or B or C and nothing else. Person includes A and B and C and nothing else. From the above example, you will see the logical difference. The list that follows means is constructed using or, whereas the list that follows includes is constructed using and. There is a legal maxim that supports the restriction of includes. The inclusion of one is the exclusion of another. That is a maxim of law, folks. And you can always remember it simply using that maxim. Or if anybody ever tries to tell you otherwise, just drop that maxim in their face and tell them to shut up. That includes a judge. The definition of the word include is key to understand your potential loss of natural person. Now, I would say not loss of natural person, but loss of your status as one of the people is a better way to put that. This is the major trick used by government in an attempt to take away your natural person rights, or I should say, your rights as one of the people. Unless you know this, you will voluntarily forfeit your rights. That's true. And then fourth trick, the government is to modify how the word includes is used in order to make an expansion of the definition when such expansion is required. This trick helps to add confusion to the use of includes, convincing most readers that includes should always be expressive rather than limiting, which is not true. Usually it's always limiting. Here are some legitimate ways in which includes is modified to become expansive rather than restrictive. Also includes, and includes, includes without limitation, including but not limited to. That's the one I usually go to. If I'm going to write something and I want to state something for what it is, but do not in the document wish that sentence to exclude everything else based on the maxim, I always use that one. I always say including but not limited to. That's the one that I always go to, and it's the best way to use it as far as I've ever found because it's the least confusing. So you'll see that in the doc set. You'll see it in the KW. You'll see it in the seal notice. You'll see it in a lot of the documents that I'll use the word including but not limited to, right? So I'm saying this, but it might include other things if I wanted to create so later. It's more or less, it's a way of saying I reserve the right to expand the list, more or less, right? The expansive definition usually take the following form. Person means A, B, or C, and includes D. However, there is also a possibility that and includes is restrictive in some constructions, as clearly 1 U.S.C. subsection 8 says. There are some people investigating this possibility right now. Their logic is demonstrated by the following example of a definition that states Providence means a province of Canada and includes Ontario and Quebec. So if we presume that and includes does provide expansion, then we must ask why Ontario and Quebec had to be specifically mentioned when they were already part of the so-called province. The above construction clearly defines the scope of what is meant by province, that it is a province of Canada. It does not say which one. And includes only Ontario and Quebec compiles from a list of 2 of the original scopes of all provinces. In this construction, means provides the scope of the definition and includes provides that list of what is actually included in the definition. Now, I very rarely see that done, but clearly it can be done, so just be aware of it. The foregoing analysis is one interpretation, but it is not the only interpretation. The use of includes in statutory definitions can be argued both ways and is the backbone of understanding interpretations. With the presumption that and includes is restrictive, then we must take a very close look at the following definition taken from the Interpretation Act. Province means a province of Canada and includes Yukon Territory and Northwest Territories and Nunavut. With this presumption, what is stated is, unless another statute redefines province, the default definition of province only includes those 3. So in order to not become absurd, we must allow for and includes to be expansive. However, more work needs to be done on the subject. Right? Okay, definitions. Barron's Canadian Law Dictionary does not provide definitions for include or means. Therefore, we have to look in the source for the definition. From Black's Law Dictionary, 4th edition, here's the definition of the word include. Include, to confine within. Hold as in an enclosure. Take in. Attain. Shut up. Contain. Enclose is compromise, comprehend, embrace, involve. Including may, according to context, express an enlargement and have the meaning of and, or in addition to, or merely specify a particular thing already included within general words theretofore used. Enclose, to surround, to encompass, to bound, I should say to bind, fence or hem in on all sides. It is stated in the above definition that the verb in a definition include does not expand the existing definition of the word it is attempting to define. It is easy to be confused because we naturally assume the existing definition of the word, then assume include means to add this new interpretation to the existing assumed definition of the word. Our assumptions fail us in this case, right? And then it gets on for, doubting Thomas, if you look up any statute, you'll be able to find the definition that uses the word includes, and when you attempt to broaden the scope for that word, you include the ordinary meaning. You will find that the statute will break down because you will not be able to support the inclusion of the ordinary meaning of the word. The breakdown usually occurs when slavery is invoked. Surprise, surprise. This is the preamble of the Declaration of Human Rights. This is a UN piece of shit. Whereas it is essential, if man is not to be compelled to have recourse as a last resort to rebellion against tyranny and oppression, that human rights should be protected by the rule of law. Honor and dishonor. This is the next really important thing about and actually I pulled this next part, the next handout 1.1, from the honor and dishonor. This section is the same section we're about to read in the Common Law Study Guide. It's just something that I pulled out separately because I wanted to make sure that people could instantly go back to the honor and dishonor part and find it quickly without having to go look for it in here. So honor and dishonor. This is the most important aspect of the law. In law, honor or dishonor is a process. It is what is done in response to a presentment. Now, presentment can be anything. It could be a notice, it could be a lawsuit, but throughout the entire process, you must be in honor. This applies to everything you do in the legal process. To act with dishonor toward the other person is the highest sin in any system of law. Higher principles. In ancient times, honor was the manner of being that we now describe as having integrity. In plain language, an honorable person avoids deception whenever possible, treats others with respect, and sticks to her beliefs no matter how others think or act. Personal integrity, allegiance to moral principles. That's the definition. The ultimate measure of a man is not where he stands in moments of comfort, but where he stands at times of challenge and controversy. That's an aspect of being in honor. The difference between a moral man and a man of honor is that the latter regrets a dishonorable or discreditable act, even when it has worked and he has not been caught. In practice, these are the things you need to pay attention to as far as to really get the point across here. So, 3 ways to honor a presentment. So, somebody sends you something, and this is anything, whether it be everything from a corporation to your neighbor, doesn't matter. So, you honor presentment either by accord and satisfaction, meaning you say, yes, I agree with what you said, and no problem, I'll satisfy what it was that you demanded from me. Meaning, yes, my tree fell on your shop or your shed, and I'll make sure to repay to put the shed back up, back to the way that it was before. Conditional acceptance is things like, yes, I'll rebuild your shed as long as we move it 5 feet farther away from the easement. You could say that. So you put your own conditions on the acceptance. And then rejection without dishonor, meaning you say to them, look, I didn't do this. I'm not in dishonor here. It wasn't my fault. But the point is that you are communicating. You are having open discussion back and forth with the other party. This is critically important, guys, when it comes to debt issues. Everything regarding the law merchant system regarding debt is all based upon notice, 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 back and forth, and notices. And then the 2 ways to dishonor presentment is argument or silence, meaning if you do not answer the thing that you were sent, then you're in dishonor. So even if it's a bunch of stupidity, you got to answer it or else you're going to be in dishonor. And that's exactly how the IRS works and exactly how the vast majority of these banks work. They'll send you a notice saying such and such or whatever. Oh, your payment's past due, something like that, right? And if you don't say anything back, the presumption is that you agree that the debt is owed, that the debt is lawful, that you owe the debt, and that they can continue with action to reclaim the debt from you. Whenever they send you a notice, you have to respond with your own notice. So I'll put a notices folder in the Pleadings library so that everybody can have the notices. And then I'll just real quick here go over what's in a notice of understanding and intent. When you get a notice from someone, go into the notices folder, then open up to notice of understanding and intent. What you'll have here is a good look at what you can use to send back to them. So notice of understanding and intent. To John Doe, whoever, please take notice of the following. Notice to employee is notice to principal. Notice to principal is notice to employee. You can also replace the word employee with agent if you need to or want to. So AB and company, hereinafter company and all employees, assigns and successors thereof, hereinafter individually employee and collectively employees, are hereby put on actual, implied, and constructive notice. Now, I'm not going to get into the definitions of what the difference between actual, implied, and constructive are, but just to say now that when you use all 3 of those, it's every single kind of notice that they basically have to answer to. So, by a woman named Jane Doe, who is one of the people of Iowa, hereinafter claimant, of this notice of understanding and intent, regarding the actions of company, and that would be whoever got a hold of you, and this is concerning the early termination of claimant from company's employment and refusal to pay a bonus check to claimant as per lawful agreement, see attachment A, hereinafter agreement, which is incorporated by reference as if fully stated herein, and shows that company would pay claimant, blah, 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 if claimant met certain requirements, so on and so forth. And you can add on to this, or you can alter this. And this is, of course, based upon this particular issue. So it'd be different for each different issue. So then you go into the cause for this notice. What you'll notice about this is that the different parts of this notice of understanding and intent are also the different parts of what you would use when you are creating a lawsuit. You go through the facts, the reason why you're suing them, so on and so forth. It's pretty much the same thing. And what I'm getting at about that is that if you do a proper notice of understanding and intent on the administrative side before you go to court, pretty much all you have to do is just take the information out of your notices of understanding and intent and put them right into your court case. So you have to write this stuff one time. All right, that's kind of the point. So claimant comes now to begin an investigation into the unnecessary and untimely firing of claimant without cause, and to investigate into the same occurrence happening to several other people just before they were to receive their bonus checks as per agreement. Right, when you say as per agreement, capital letter A agreement, up here you have defined what agreement is. This is how you can define things so you don't have to keep saying what it is, right? So as regarding the actions concerning the company's employment and refusal to pay a bonus check to claimant as per a lawful agreement, see attachment A. So whenever you then say hereinafter capital letter A agreement, then all you have to say that is in the rest of the document. When you use capital letter A agreement, it means whatever the hell it was you said it meant hereafter, right? And you can shorten up a lot of pages of a document by doing that, particularly if you have a lot of various different things that need to be specifically defined. So claimant presents this notice to company and employees. Both company employees are capitalized, meaning they've already been defined, as has notice. So claimant and as claimant. So claimant presents this notice to company and employees as sufficient fair warning to allow employees the time to exercise due diligence. That means figure out what's going on and inquire further into matters stated herein. That means talk to me. So as to discover that which an inquiry pursued in good faith, because if somebody's not doing something in good faith, then that's something they can be sued over, would disclose. And then put a little case law in there. Knowledge of facts which would naturally lead an honest and prudent person to make inquiry constitutes notice of everything which such inquiry pursued in good faith would disclose. Claimant gives this opportunity to company employees so that company and employees may correct their errors before claimant files suit against company and employees for trespass on the case, account unsatisfaction, breach of contract, debt, constructive fraud, unconscionability, and whatever the hell else you got to go up against them for. In a court of record regarding claimant's rights and titles to whatever. That would be not the land, because this is a hodgepodge of a couple different notices that got put together. According to title, there should be rights regarding claimant's rights and I'd say duties of the agreement, capital letter A. It'd be something like that. The land thing was in here, like I said, from a previous notice. So anyway, claimant claims, now it's just switching, but the point is that you're doing the cause. Why are you doing it? So this other paragraph was actually for one that was dealing with property tax issues. So claim said land along with rights, privileges, and immunities thereof under the common law as one of the people of Illinois. Claimant refuses for cause without design to pay any tax on land unless company or employees can rebut the following listed facts, produce the law upon which they rely to make the assertion that they may tax privately held, non-commercial land, and answer the questions listed in notice regarding statement. For no one is bound to fulfill a duty to a contract in which fraud or coercion are present, or where meeting of the minds is absent. Notice is being presented to company and employees within 10 days of receiving statement. And then you list your factual background. Now this one, I think, like I said, is okay. So the facts that are listed in here from when somebody sent this in as a notice regarding property taxes. So just have some context here. Employees are trustees of the people of Illinois. True. Claimant is one of the people of Illinois. True. Now, since you've put that down as a fact right there, unless they rebut this notice that you sent back to them, you can use this notice in court and say, Your Honor, they've already agreed that I'm one of the people of Illinois. They will be stuck with that. They will stipulate to it, and the judge will force them to stipulate to it because that's how this law merchant system works. Claimant on November 2nd, 1957 has been found to be living. Right, again, don't rebut it. Here, you're going to stipulate to it. Claimant's proper name is John Henry. Claimant is of his own house, the name of which is Doe. Doe, John H., is a fiction of law, and therefore a fictitious name. Claimant has never knowingly asked for and heretofore waives all benefits from company employees. Claimant claims land to have and to hold the same, together with all rights, privileges, immunities, appurtenances of whatever nature, hereunto belonging, as one of the people of Illinois, as and assigns in chain of title from Alexander McAfee, who was the original holder of the original land patent. Claimant has no knowledge of any lawful contract in which he is beholden to or owes a duty to company or employees. Company employees have attempted to, by trick, have claimant assume the status of a tenant on land to extract funds from him by mistake, by use of the postal service so that he would assume said status willingly. Company employees have attempted to, by trick, have claimant assume the status of a taxpayer, to extract funds from him by mistake by the use of the postal service so that he would assume said status willingly. And it goes on and so forth. But anyway, so there's your facts. So you state all your facts of whatever's going on. Then, if you want to, you can put in questions. Questions from claimant regarding statement or regarding whatever the hell the issue is. So then you list your questions. What are you doing? Why are you doing this? Is this what this is? Is that what that is? So on and so forth. But then you give them the law. The law of this matter is hereby decreed. Since we're getting into this in a notice, I'll just bring it up now, but we'll get into it later as well. When you do your law of the case in your original lawsuit, meaning if you were going to sue the county, like this gentleman is, suing the county over title to his land, when you write up the suit and then file it, what you'll have as part of the suit, it's called the law of the case. And this I don't call it the law of the case because it's not yet a case yet. We're still dealing with just a motion. So I just say the law of this matter. So I say the law of this matter is hereby decreed by claimant. Why can you decree law? Because law, by definition, at least by various different case law, means literally the decree of a sovereign. Are you sovereign? Yes. Can you decree law then? Yes, you can. So, therefore, you can do it here too. The law of contract state that one must understand and comprehend the agreement that one is entering into in order for an agreement to be valid. A man's property is all that is his in law. 1848 Wisconsin Constitution, Article 1, Section 14. Now this one's just fun, in case anybody doesn't know this one. All lands within the state are declared to be allodial and feudal tenures are prohibited. Feudal tenures are prohibited. Are we in feudalism? No. Do I have a higher landlord? No. Do I have to pay your tax? No. So, they don't argue this. They stipulate to it. If one holds another to answer to an agreement, they did not nor could not comprehend nor understand this is a form of fraud. An agreement induced by fraud will not stand, which is the maximum law. Claimant is not bound by legalese latches, meaning I'm not bound by any of your crazy language that you've defined 25 different times that I don't understand. Forget it. I'm not bound by it. Period. Public officials are properly subject to public scrutiny in the performance of their duties. Anchorage versus Anchorage Daily News, Alaska, so on and so forth. The people of this state, as successors of the former sovereign, are entitled to all the rights which formerly belonged to the king by his prerogative. Lansing versus Smith, that's one you guys should just memorize. And there's other various forms of law. So you're laying out the law regarding whatever matter you're dealing with these people. And that gets fairly extensive, as you can see, because it's dealing with land. So it goes on for several pages. Injuries. This is where you tell the guy, or people, or corporation, whoever, what was the harm that they did to you? So because of the aforementioned actions of company employee, claimant has been injured in the following ways. Claimant has been deprived of his title to land without lawful cause or authority. Company employees have attempted to, by trick, falsely label claimant as a tenant to extract funds from him by mistake, so on and so forth, yada yada. So these are the injuries that you sustain. Duty. Company employees. So this is where you tell them where the duty is. So where, if they were to stay in honor, this is what they have to do. Company and employees have both a moral, legal, and lawful duty not to cause injury in accordance with the universal imperatives. Company employees must not engage in any activity such as fraud, theft, lying, or conspiracy to commit fraud, which would be an unwanted injury to another. Company and employees have a fiduciary responsibility of honesty and integrity as trustees of the people of Illinois. Those universal imperatives are part of the common law of the land and codified in the codes of the state of Illinois, i.e. Criminal Code and Civil Code. Company and employees have a duty to return all property, titles, and monies belonging to claimant that they are holding by mistake. Company employees have a duty to not cause damage, harm, loss, or injury to land or property of claimant. Company and employees have a duty not to misrepresent their position in relation to claimant, meaning you can't come in here and just say you're above me because you say so. That's not lawful. Produce the law on which you rely to make the assertion. Everybody better memorize that one too. I'll just type it out in here. Duty. Let's do it like I was going to write more of this out. So I copy and paste. So I'll say company employees have a duty to produce the law upon which they rely to make the assertion that they can, I would say, can tax land held in allodial title. So there you go. So there's another duty. But this part right here, produce the law upon which they rely to make the assertion, this you can use anywhere. You can use it in court. You can use it in front of a clerk. You can use it to a district attorney. I don't care. But it's absolute. If they can't produce the law, then they're what? They're being unlawful. Their demands are unlawful. Their actions are unlawful. And I can almost guarantee you, almost every damn time, they're going to, if they do produce a law, it's going to be something that has the word person in it. Great. You know what to do with that one. So, breach of duty. Companies and employees have breached the aforementioned duties by the use of fraudulent documents to extract taxes by mistake from claimant. Company employees have breached their duty and created fraudulent instruments of encumbrance on said real property, all contrary to claimants' allodial right to have and hold land. Meaning, encumbrances meaning taxes, tax bonds, tax warranty deeds, tax deeds. All that's an encumbrance, an unlawful encumbrance. Company employees have breached the aforementioned duties by working together to take property of claimant without lawful authority. So now they have to prove what, all right, prove the authority. They don't prove it, then they stipulate to the fact that this is a breach of their duty. Company's employees have sent envelopes labeled important tax bill enclosed when no bill is to be found in said envelope. What we found was that it said, when we opened it up, it said receipt. Or it said statement. A receipt is a proof of payment. And a statement is just a statement. Doesn't mean anything. It's not a bill. There's 9 parts to a proper bill. And trust me, they don't ever put them in there. And then, after that, after you told them, I'll scroll back over here just for a real quick overview. So let's go back over the sections real quick. So cause, why am I doing this? Factual background, state the facts. Questions, meaning please answer what these questions are so we can, get clear here, so we can both stay in honor. Law of this matter, state the law. Injuries, how you were harmed. Duty, what they have a duty to do to you, for you. Breach of that duty. And then demand. Claimant demands from company employees the following. So then you give them the demands. What's going to happen? All right, a full accounting, including but not limited to. Here's right there, including but not limited to. See how I did that? A full accounting, including but not limited to all warrants, bills, bonds, deeds, encumbrances, liens, debts, transfers, records, accounts, easements, and fees, which company or employees are custodian of or custodian of which have been or are being used in relation to any right, privilege, interest, ownership, or use regarding land within 90 calendar days from the serving of this notice to claimant. Give me an accounting. This is my land, it's not yours. So give me everything you got. Technically, you could wrap this also in, if you wanted to continue this little thing like this, is say, as per State Open Records Requests Act, statute, code, whatever, blah, blah, blah. Because here's the thing. You never want to use statutes, acts, ordinances, and codes to justify you doing something. You always want to use statutes, acts, ordinances, and codes when you're using them against them. They're bound to them, not you. So you can use statutes, acts, and codes to say, look, this is what it says you have to do. But you never do that the other way around. You never purposefully put yourself under their law. And this gets into more things that we wanted them to do. I'm not going to read all this. And then default. So what's going to happen if you don't do my demand? Default. If company employees fail to satisfy the demand within the allotted time after having been duly served with this notice and demand, duly served means process served, by the way, then by tacit procuration, that means, okay, I got to explain this. By tacit procuration, that means by assumed power of attorney. It means you can take power of attorney over them and just make them do whatever the hell it is you want them to do. That's what by tacit procuration means. Okay, so just make a note of that. Claimant or his nominee or his assigns will determine for company and employees the following: that the aforesaid demand is just, that a court of record may enforce that demand, either ex parte or con parte. That means I don't give a damn if you show up or not. I will default you. You don't believe this has any power? You don't believe in courts of record? You don't believe in common law? Great, I don't care. I'll default you, I'll show up at your house, and I'll throw you out of it. Try and stop me, I'll shoot you. End of discussion. that companies and employees and each of you concur and are satisfied with the justness of the demand and the process by which the demand shall be enforced. That means if I enforce it by a court of record, that's the enforcement, period. I don't have to follow your filthy law, your statutes, acts, ordinances, and codes. I don't even have to go get the sheriff. I can go get 25 members of the militia and do it if I want to, if that's how I feel like enforcing it, because you will agree and concur and are satisfied with the justness of the demand and the process by which the demand shall be enforced. There are no rules here, people. We have to start acting like sovereigns and do what you need to do to get things done. And tell them you're going to do it too. Be right up front with them, right in the beginning. This is how I'm going to default you. Don't like it? Take care of it. Fix what the problem is. Because I can guarantee you're not going to keep stepping on my toes. To continue, that claimant will determine for company employees and each of you the law by which company and employees and any others working with company or employees shall be bound in said court of record. What did you just do? You just warned them that you're going to decree the law. In different words, but that is what you just said. Further, if company and employees fail to satisfy the demand within the allotted time after I've been duly served with this notice of demand, then claimant will take lawful action in a court of record, in personam and in rem. That means against the person and against the thing. 1. To defend against any of you or persons acting in concert with you who have caused any injuries to claimant. 2. To secure his substantive rights. 3. To redeem the aforementioned listed property of above that is now by right the property of claimant. To seek damages for any trespass committed by company and employees. Now, why is that important that you have to say that? And I'm talking about this, well, all of this part, but specifically the first one. To defend against, so I'm going to, if you don't satisfy it after I've been served, then I'm going to take lawful action in a court of record to what? Defend against any of you. You never, ever, ever say, I'm going to sue you. You say, I'm going to defend myself against your stupidity, even though you're the one filing the suit. But you never threaten to sue someone. This is how you can properly get away with threatening someone without being charged with a crime, or without them trying to use their filthy Khazarian mob system to try to charge your estate with a crime. You say, I'm going to defend against any of you. That's how you say it. It's basically like the same thing as like putting up a no trespass sign on your fence. Cross this and get shot. You gave notice. They want to get shot, that's their problem. And then in the end, just a little boilerplate stuff here. Please do not contact me by telephone, yada yada, and John Doe Henry, whatever, and then give me your address. I, John Henry, D. Bioki, am the claimant in this lawful notice for cause without dishonor. I declare under penalty of perjury and the laws of the United States of America that the foregoing allegations and statements are true and correct, except as to matters that are stated on my information and belief, and as to those matters, I believe them to be true. This is part and parcel of how you do a complaint in equity. You say, as stated on my information and belief, as to those matters, I believe them to be true. So you just say, you believe everything that I said is true. That's basically how you're getting at. And then signed, and of course your CO would go over here. That's why I love the space. So, from the standpoint of doing a notice, that's how you do it. That's the notices section about how it works. Let's go back to the study guide now. So now we know what honor and dishonor is. We know how to honor a presentment. You know how to dishonor a presentment, or how a presentment would be dishonored. We showed in the notice and demand example how you do that correctly. So honor, accord and satisfaction. CD honors by accepting the presentment without recourse, and then satisfies whatever is demanded in the presentment. Example, AB presents a bill for services, CD pays the bill. Conditional acceptance. CD honors by accepting the presentment, but with conditions. Effectively, that is a counteroffer from CD to AB. AB would then accept the counteroffer as a new presentment from CD. Example, AB offers his house for sale, CD accepts the offer provided that the house is first painted. 3. Rejection without dishonor. CD rejects the presentment because it is defective. Example, AB presents a bill for services, CD returns the bill because there is an error, perhaps the price is wrong, but will accept the bill once the error is corrected. Dishonor. Argument. CD rejects, dishonors the bill. There is no basis for rejecting the bill. The arguments have no relevancy to the presentment. Often ad hominems, meaning you're a dickhead. Irrelevant comments against AB accompany the rejection. get the hell away from me, you scumbag, whatever hell, right? Or a bunch of threats. And usually when people, and this is again, gets back to right state of mind. You start getting into ad hominems, which is a fancy way of saying an attack against a man in Latin, and this is a logical fallacy, that it has nothing to do with what's actually going on. Yeah, the guy might be a total asshole and he might beat his wife, but that has nothing to do with the fact that he owes you money. Okay? Nothing. So keep that stuff out of there. Silence. CD simply does not respond to the presentment, but remains silent. This presentment is thus dishonored. Now this is what I'm talking about. Before going to court. So AB makes a presentment to CD. If CD honors the presentment, AB acts accordingly. So long as each party honors the other presentment, the process can move forward to resolution. If CD dishonors AB, then AB grants grace and repeats the presentment. That's what we do with the 90 days. And I should put this in here. Maybe I'll put it in here as a little note. So first notice, you give 30 days. Second notice, you give another 30 days. And then what you call the final notice, you give another 30 days. This way, you're repeating it over and over and over to them that they have these various different things that they have to do. And that's important because and this goes all the way back to maritime admiralty law, in the ancient Mediterranean, and this goes back way into the BCs, that if you'd have a ship show up and you were waiting arrival of something from some other port, say you were expecting 100 barrels of olive oil from Italy, and say you were in France. And so you're sitting in France waiting for your olive oil. You see the ship come in, say, aha, my olive oil is going to be there. And so you get your stuff, get your guys ready, say, hey guys, go get ready to unload, get the carts ready, let's go get our stuff, right? Get down to the ship. The captain presents what's called a manifest to the port authority or the dock. Once the port authority learns of the manifest, these things, which weren't there yesterday, but then just manifested themselves off the sea, are now then to be considered as a accounting of what is now in the country. So this is why you have things like port authorities and whatnot. How many cars do you have on there? How many 100 bushels of grain do you have? In this case, how many barrels of olive oil you got? You get the olive oil and it's on the ship. The captain gives the manifest to the port authority. The port authority then makes a record of it, so on and so forth. When you come to have livery of the olive oil, you bring your receipt as to the fact that it is definitely yours, and the captain and you would both sign off on it saying, yep, the captain brought it, yep, I got it. Captain's relieved of all the rest of the liability because he's delivered the goods, right? Okay, what if there's a problem? What if you unload the ship and you've only got 90? They counted again, only got 90. Counted a third time, we only got 90. Okay, what would happen was that a notice would be given then back to the captain from you because you got only 90. So, or not necessarily, if that captain wasn't necessarily going back to the same port that he just came from, where you got the olive oil from, then you would make sure that a notice was sent to, on another ship, to the port of which you did just get the olive oil from. Doesn't necessarily have to be the same captain. But let's just take this example that the captain's going back to the same port. So the captain goes back to the same port. The notice goes back. The man who you bought the olive oil from gets the notice. Okay, this now gets into what we were just talking about. This gets into our process. So what can the guy do? Well, back up here in practice, he can accord and satisfaction. Oh, there was only 90? Okay, I'm not even going to question it. I'll just put 10 more on the ship and write another receipt out that there's 10 on the ship, and it'll come back to you. And when you get it, you get the notice and you get the 10 barrels, right? Or the other guy who sold the olive oil could give you a conditional acceptance. He could say, well, I'll send you the 10 barrels. Well, in this scenario, that'd be and it would be difficult to do a conditional acceptance. But okay, let's just say it this way. say he gives a conditional acceptance and says, I'll send you the 10 barrels on the next ship back if you produce for me a notary copy receipt of the manifest at the port, that the manifest said that there was only 90. And he said, okay, fine. So you do that, you send it back to the same port. He reads the manifest, he goes, okay, fine. Then he puts the 10 barrels on and he sends it back over. Or he could do a rejection without dishonor. He could say, okay, I understand the fact that you only got 90, but it's not my problem. It wasn't me. Take it up with the captain. The captain took them. So you could do that too. He could do an argument and, call you a bunch of ad hominem names and say, I think you're lying and blah, 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 yada, yada, yada. And of course you'd respond with, you're wrong because these are all the manifest and this is what the captain's ship had. And there were 5 men with witnesses that only counted 90. And say they only counted 90 before they took him off the ship, right? Or just silence. He doesn't say anything. Let's say for this example, he doesn't say anything. Let's say he dishonors the presentment. So you send it to the port, dishonors the presentment. You wait till the time at which you're pretty sure that he got it, and you should have gotten a notice back from him. Let's just say, for example, this ship only takes, say, 5 days to get back and forth between Italy and France. So you wait 30 days, silence. You don't hear anything from him. So then what you do, you send a second notice, right? So you say, okay, you repeat it. So you don't know what's going on, so you send the second notice. So then if he dishonors it a second time, then makes an affidavit of the history of the presentments, meaning you take the first notice, you take the second notice, and you make a copy of it, history, and say, yep, and I sent this, and yep, and in this case, in our modern world, what a notary can do for you, and this is a really interesting way to use a notary, you can give the documents and the notices, meaning the understanding of notice and intent that we just ran over, you can give these to a notary and you can have the notary mail them certified mail return receipt requested. And what's going to happen, and here's the thing, because a notary is an officer of the court, just like the Port Authority would be the same way, like an officer of the court, that they can write out and swear behind their full commercial liability that they did mail the notice to the other guy. And when you have a notary do that, then you can use the notary affidavit on top of it. So it says, this affidavit is given to a notary public. The notary is requested to make, in behalf of AB, a formal presentment to CD. Now you'd write out the presentment, the formal thing. All the notary does is just sign it, seal it, and send it. And it'll say something like, I, notary so-and-so, have mailed such and such and this and that, and have a record of it in my office to be presented in court, something like that. So then he sends it back. So then if CD dishonors the presentment, the notary grants grace and repeats the presentment. Now the notary is the one that's doing it, right? Then if CD dishonors the notary a second time, the notary makes a certified history of presentment. The history is given to AB. So you did it, notice, disgraced, second notice, disgraced. The notary did it,